text messages, probably mostly from Thomas. Okay, so continue that and get rid of this on the screen. And I'm going to move this to the side. Okay, so good day, everyone, and welcome to my presentation titled Beyond Winn-Dixie. As the title of the presentation suggests, the theme of my presentation is going to pivot around the recent 11th Circuit opinion in the Winn-Dixie case. Thomas Logan and I actually have a long shared history around Winn-Dixie, and Thomas has somehow forgiven me for introducing him in the first place to Scott Dienan, the attorney for the plaintiff in Winn-Dixie, and suggesting that they work together. But that's fodder for a future podcast or blog post. I also presented on Winn-Dixie specifically only about a month ago with the folks at 3Play Media, and I went pretty deep into the woods about that decision in that presentation. Since then, however, there have been a few new developments that reinforce what I'd mentioned in that presentation. Plus, I've also had some time to think a little bit more broadly, and I wanted to talk about the bigger picture around how courts are dealing with the avalanche of web accessibility lawsuits in this country, and specifically how the Winn-Dixie decision fits into that. So, and then there's the recent Domino's pizza case that people have been asking me about. It serves as a nice foil to the Winn-Dixie case and some of the more recent negative trends that we've been seeing. So I'll touch on that briefly as well. So if your focus is just on Winn-Dixie on the 11th Circuit, I'd suggest you watch my presentation from last month. But if you did watch that presentation, I promise you that this one will overlap it, but still be very different from that one. Okay, so let's see if I can switch slides here. Yep. Okay, great. Because I'm a lawyer, in addition to being a consultant, I have to start with a disclaimer. Please note that nothing in this presentation should be interpreted as legal advice or as forming an attorney-client relationship. Before acting on any information in this presentation, you should seek assistance from a licensed attorney in your state. So most people think that lawyers are just protecting themselves by saying this, but it's actually meant to protect you. The direction you take in advancing your rights is dependent on a ton of factors, and we're only going to touch on a few of them today. And having an attorney who knows all of your factors, and especially the ones that are unique to you, is the only way to make confident decisions. So let's see, switch the slide again. So who am I to be opining about this stuff? Well, my name is Ken Nakata, as Elise mentioned, and I'm a principal and co-founder of Converge Accessibility, a consultancy that I formed with my business partner, Jeff Singleton, about a year ago. We're somewhat unusual among consulting firms because we bring an equal share of legal and technical knowledge around web and digital accessibility. Before we started Converge, I used to be a senior trial attorney with the U.S. Department of Justice in the disability rights section. And for 12 years, I investigated and litigated cases under the Americans with Disabilities Act, or ADA, and the Rehabilitation Act for the DOJ. I also helped write the original Section 508 regulations with my colleagues at the U.S. Access Board, and I was the lead counsel for the federal government's interagency Section 508 working group, which brought together all of the different federal agencies to coordinate how to make the federal government's IT systems accessible to people with disabilities. I also helped create the Department of Justice's policies for application of the ADA to websites. I wrote the technical assistance guidance, which is titled Accessibility of State and Local Government Websites to People with Disabilities, which you can still find at the DOJ website, ada.gov. From a technical perspective, I also wrote the Access Board's original technical assistance guidance on coding accessible websites. So even though I don't practice law anymore, I'm still an active member of the bars in New York, the District of Columbia, and Washington State, where I live. Let's see, I'm having trouble transitioning here. Okay, so at Converge, we try to apply our diverse backgrounds in ways that are a bit different from other consulting firms. We have a strong focus on helping companies become more proactive and really own accessibility. So while manual audits and automated testing will always be part of the solution for really big organizations, we also help companies make accessibility simpler and just a regular part of their web development process in the most cost-effective way. As web accessibility litigation has exploded, a lot of companies are finding that they have to constantly fix their sites over and again in response to the latest lawsuits. But simultaneously, web accessibility has matured, and these same companies know that they can do better and fold accessibility requirements into the web development cycle better. If you find yourself in that situation, please reach out to us because we've got a far simpler solution for you. Another way that we're different is that we work with a lot of law firms, mostly on the defense side. We help attorneys understand the technical issues in web accessibility, as well as some of the latest developments in case law around web accessibility. So one consequence of the avalanche of litigation that we've had recently is that the law is constantly changing. And I think that every noteworthy consulting shop in web accessibility has their place. Over the past 20 years, we've worked in accessibility. As Elise mentioned, we've worked a lot with the team at Equal Entry, both as coworkers in the same company and as partners in different companies. But if web accessibility legal issues interest you, I'd encourage you to sign up for our mailing list. We post new content at least weekly, and more than half of our posts focus on the latest legal developments. I actually found out about the 11th Circuit opinion in Winn-Dixie, read through it, and blogged about it on the same day that the decision was announced. It was my good friend Mark Dubin, who also worked at the Justice Department with me, and who now lives in Florida, one of the states in the 11th Circuit, who gave me the heads up on the decision. And if you were on our mailing list, you would have had all that information on the same day. So let me give you a quick sense of where we're going. We'll start with a brief overview of the Winn-Dixie opinion. And after that, we will, well, again, I don't want to repeat everything that I said in my presentation last month. And if you'd like a copy of that presentation, you can reach out to me directly, as it hasn't appeared on the 3Play Media website yet. As I mentioned, we also have a very active blog at Converge Accessibility and post at least once a week. And there's a link from there directly to that video. But as I mentioned at the outset, I want to take a step back and think about how Winn-Dixie fits into the larger landscape of legal issues in this country, and specifically how it fits into the pattern of attempts to limit this overall scope of the ADA when it comes to web accessibility. As a judicial opinion, Winn-Dixie really irritated me more than any recent decision because it really did reinterpret the scope of the ADA. A more sensible way of handling the avalanche of web accessibility cases is to make it harder for plaintiffs to bring hundreds of web accessibility cases in the first instance. In general, this works relatively well, but sometimes it adversely impacts honest plaintiffs unnecessarily. So after years of working in this field, I find myself coming right back to the same position I had when I started, that the most effective thing that we can do is to encourage the Department of Justice to complete its accessibility rulemaking. So we'll end by talking about the recent Domino's decision, which I think makes a nice foil to the conservative approach taken in Winn-Dixie and raises a very different approach to web accessibility litigation in a forum that's rapidly replacing the 11th Circuit. Plus, the latest Domino's decision raises some other fascinating legal issues that everybody should be interested in. So let's start by talking about the Winn-Dixie decision and how it fits into the bigger picture of web accessibility. Okay, and to do that, we need to know what happened in Winn-Dixie. So I'll try to keep this part brief, but in essence, Winn-Dixie involved a blind plaintiff named Juan Carlos Gill, who was a frequent plaintiff in Southern Florida. Mr. Gill often shopped at Winn-Dixie, but couldn't access their website. Unlike a lot of retailers, Winn-Dixie doesn't sell anything directly on their website. Instead, Mr. Gill was interested in online coupons to help him save money when he visited a store, or refilling his prescriptions online, so he wouldn't have to wait for hours to have his prescriptions refilled. Because Winn-Dixie's website was inaccessible, however, Mr. Gill had to find someone at his Winn-Dixie store to tell him about the physical coupons he could use. and to get his prescriptions refilled, he had to first tell the pharmacist and then wait hours for them to start and complete the refill process, while other non-disabled customers could just come in and pick up their refills immediately. Of course, Southern Florida, where Mr. Gill lived, was the nation's first hotbed for web accessibility lawsuits. While attorneys in other parts of the country were more successful using demand letters, plaintiffs in Southern Florida resorted quickly to the federal courts. And almost all of those cases settled quickly. But Mr. Gill's lawsuit against Winn-Dixie was one of the first ADA web accessibility cases to go all the way to trial, and he won. So one hurdle that the district court had to get past was the language of the ADA. The ADA requires a so-called places of public accommodation, not discriminate against people with disabilities. The word place is very critical here, and we'll have more to say about that in a few minutes. But for our quick summary of the Winn-Dixie case, the district court had previously ruled that the online coupons and the prescription refill service had created enough of a connection or a nexus to a place of public accommodation that Mr. Gill could sue Winn-Dixie over its inaccessible site. The court then went on to hold that Winn-Dixie's website violated the ADA, and it required Winn-Dixie to make it accessible. Winn-Dixie appealed from the trial court's decision, in this case, the U.S. District Court for the Southern District of Florida, to the appellate court, which in this case is the 11th Circuit Court of Appeals. The 11th Circuit encompasses Florida, Alabama, and Georgia, and its rulings need to be followed by the federal district courts in those three states. In any event, the 11th Circuit said that the district court was wrong. Specifically, the 11th Circuit held that the strength of that connection between the website and Winn-Dixie's physical stores wasn't strong enough for Winn-Dixie to be liable for having an inaccessible website. Now, this may be getting terribly abstract right now, so let's review. First, the ADA is written to prohibit discrimination at places of public accommodation. Second, some courts, for example, the 11th Circuit, say that websites don't count as places of public accommodation unless that website has a really strong connection to a physical bricks and mortar, traditional kind of physical place of public accommodation, like a store. And third, online coupons that can be redeemed in a physical store, or an online prescription refill service or pickup at a physical store, those don't create a strong enough connection. Now, this really is a departure from every other circuit in the country. For instance, a common approach taken by other circuits is the so-called nexus approach. In those circuits, a plaintiff also has to show some connection between a website and a physical bricks and mortar physical location in order to bring a lawsuit alleging that the website was inaccessible and violated the ADA. The Winn-Dixie approach is noticeably different from the nexus approach, and the 11th Circuit and Winn-Dixie took pains to clarify that they were not using that standard. So I like to think of the 11th Circuit approach and Winn-Dixie as the gateway approach. In effect, the 11th Circuit is saying that just establishing that connection or nexus is irrelevant. Instead, a plaintiff has to show that there's some inaccessible feature in the website that effectively barred someone from accessing goods and services at a physical store. Apart from having no legal basis, this kind of test is also completely removed from reality. Winn-Dixie would have to require customers like Mr. Gill to order prescription refills only online and then pick them up at a physical store. Or Winn-Dixie would have to offer its coupons only online and then let those coupons be redeemed in a store. But this simply isn't the way that businesses operate. According to the 11th Circuit, as long as there's some way to get the same benefits that are available on its website, people with disabilities would just have to accept it. The opinion relegates people with disabilities to the back of the bus. Instead of having equal access to coupons, people with disabilities would have to cajole strangers to read coupons to them. Instead of quickly refilling prescriptions, they get singled out to wait for hours to get their prescriptions refilled. So the 11th Circuit's decision in Winn-Dixie irritated me because of its really cavalier approach towards the ADA and the rights of the disabled. After all, the ADA isn't just some technical set of requirements like the tax code. Instead, it's a civil rights law, and it's intended to redress generations of past wrongs. The ADA is virtually silent when it comes to the phrase place of public accommodation, and yet the courts treat it like the term place was carefully negotiated in Congress. There's absolutely nothing in the legislative history discussing where the word place comes from. Instead, it's my understanding that the word place, um, instead, it's my understanding that Congress just lifted the term place of public accommodation from the 1964 Civil Rights Act. So on the screen, I have a screenshot of what happens when you look up the Civil Rights Act of 1964 in Lexis. You get an ancient 56-year-old scanned image of the original bill. Now, I just happened to be born in 1964, and it just makes me feel old. But it also indicates that the term place likely wasn't thought about too carefully when the ADA was passed. It's ironic that the term place of public accommodation comes verbatim from the Civil Rights Act of 1964, which was designed to combat racial discrimination. Would the 11th Circuit say that companies like Winn-Dixie could discriminate on its website against racial minorities just because that discrimination didn't happen at a physical store? There's hardly any case law under the 1964 Civil Rights Act defining place of public accommodation, but I can't imagine any court making that kind of ruling. Yet the 11th Circuit seems to have little trouble taking that same language and saying that people with disabilities have to put up with added burdens when they try to access goods and services through a website. To suggest that the term place should be so narrowly read only suggests that the court has little regard for the rights of people with disabilities. And while I can appreciate the court was likely responding to the deluge of web accessibility cases in the Southern District of Florida, undercutting the ADA's impact is not the way to do it. As I mentioned, we spend a lot of time helping defense attorneys fight against the deluge of frivolous web accessibility cases. Every day, I help defense attorneys understand how to fight in their clients' interests and when to settle a case in terms that are most favorable to them. Nonetheless, I'm also happy to call a spade a spade. The 11th Circuit opinion in Winn-Dixie is awful and undercuts the rights of people with disabilities. So while I think that the 11th Circuit's Winn-Dixie decision is terrible, I think that ultimately it's not a source of great concern. First, plaintiffs are already moving away from the Southern District of Florida, and the 11th Circuit and the Winn-Dixie, they're moving away from the Southern District of Florida and the 11th Circuit, and the Winn-Dixie decision has absolutely no effect on New York and California, where the real action is. Second, I think that there's a good chance that the opinion is going to get reversed. Shortly after the decision was announced, plaintiffs and disability rights groups from around the country, such as the National Federation of the Blind and the National Council on Independent Living, they all piled on to have argued to have a rehearing en banc, meaning before the entire panel of the 11th Circuit, and not just the 3-judge panel that made the Winn-Dixie decision. In my other presentation on Winn-Dixie, I discussed how courts in the 11th Circuit have been all over the place when it comes to web accessibility. On the one hand, you've got decisions like Rendon versus Valley Crest Productions and Haynes versus Dunkin' Donuts that have read the ADA more broadly, while decisions like Access Now versus Southwest Airlines and now Gill versus Winn-Dixie seem to slam the door shut. But we don't have time to discuss the legal nuances distinguishing those cases today. And again, I refer you to those other presentations, to my other presentation, if you'd like to understand those cases and how Winn-Dixie evolved from them. So to give some sense of how the 11th Circuit opinion is an outlier, it helps to understand how the federal judiciary in our country works. Federal courts throughout the country have struggled with this question of whether a company can be sued under the ADA for discrimination that occurs outside of its physical place of business, such as through its website. As different circuit courts have taken different approaches, this issue has created a split in the circuits. So our country is divided into 12 circuits, with each circuit containing 1 or more district courts. Some circuits are enormous and others are quite small. For instance, the DC Circuit only includes only 1 district court, Washington, DC, while the 9th Circuit includes all of the Western states and hears appeals from 15 district courts. So when we say that there's a split in the circuits, we mean that different groups of courts take different approaches, and unless they change their mind or the Supreme Court settles that split, where you bring your lawsuit will have a big impact on which way the court's going to go. So the most popular approach is the so-called nexus approach, which is followed in the Third Circuit, which is Delaware, New Jersey, Pennsylvania, and the Virgin Islands, the Sixth Circuit, which is Kentucky, Michigan, Ohio, and Tennessee, and the Ninth Circuit, Alaska, this is a long one, Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, Washington, Guam, and of course, the Northern Marianas Islands. So until the Winn-Dixie decision came along, we used to put the 11th Circuit, which is Florida, Alabama, and Georgia, in here as well, but not anymore. In these jurisdictions, a plaintiff has to show that there's some connection or nexus between a website and a physical bricks and mortar place of public accommodation. This can be shown with things like a store locator feature on a website, or coupons that are redeemable at a physical store that can be downloaded from a website, or being able to place orders online and then return those orders at a physical store. Features like that would create a nexus. The fact that the Ninth Circuit follows the more relaxed traditional version of the nexus test is important because California is rapidly becoming the venue of choice for web accessibility lawsuits. An even more liberal approach is followed in the First Circuit, which is the New England states, Maine, Massachusetts, New Hampshire, Rhode Island, and interestingly enough, Puerto Rico, and the Seventh Circuit, which is Illinois, Indiana, and Wisconsin. In these circuits, a physical place isn't required at all. This means that even purely online companies with absolutely no physical place of public accommodation could be sued. Courts in these circuits recognize that the term place of public accommodation is largely historical leftover, and that the broad remedial purpose of the ADA would make it simply unfair for companies to engage in discrimination through their online activities. More recently, district courts in the Second Circuit, which includes Connecticut, Vermont, and New York, and even the Fourth Circuit, which is Maryland, North Carolina, South Carolina, Virginia, and West Virginia, have declared that they're following this same approach. Now, this is really important because the U.S. District Court for the Southern District of New York is now where most web accessibility cases are brought. Simply put, far more web accessibility lawsuits are now brought in New York and not in Florida. So, while judges in New York may not be happy by the serial plaintiffs who bring hundreds of web accessibility cases in their district, they've been able to eliminate a lot of them without undercutting the ADA. For instance, they routinely dismiss cases because the plaintiff had not clearly identified the inaccessible features of a website and how they directly had an impact on them. Our courts have also dismissed cases because the plaintiff could not prove that they had any genuine intention of becoming a customer of the business, or they had simply filed too many complaints and so were declared a vexatious litigant, thus requiring them to obtain court approval before filing a similar lawsuit in the future. In our blog, I discuss many of the ways that courts have dealt with the flood of frivolous web accessibility cases without undercutting the ADA and the rights of people with disabilities. But this approach is far from flawless, and I'll have a few words about some of the problems with this approach later. So, in addition to seeing more ADA web accessibility cases move away from Florida over the last several years, we've also noticed another trend: cases moving away from the ADA entirely. Over the last 2 years, there's been a noticeable uptick in a number of cases that are being brought under California's Unruh Act in California state court. This is likely motivated both by the attractiveness of California state courts, such as lower filing fees and a more liberal bench, but even more likely, liquidated damages of $4,000 per claim, which are available under Unruh. So remember that Target case from a few years back? The only reason that Target agreed to settle for $6 million is because of those liquidated damages involving hundreds of California NFB members who joined the lawsuit. I think it's helpful to remind ourselves why web accessibility cases are creating such a problem for companies and the federal courts. Since my last presentation, Jason Taylor over at UsableNet published his annual review of web accessibility litigation. So Jason's really quite amazing at keeping up with all of this on the data side, and so are the attorneys over at Safe Arts Shaw. They've both been collecting data on the number of web accessibility lawsuits filed each year in our federal courts. And while the numbers don't match up perfectly, they're consistent enough to paint a clear picture of the pattern. So before 2015, there were hardly any web accessibility cases. Then in 2015, there were only 57 federal cases filed in the entire country. In 2016, this number increased to 262. 2017, it was 814. Then 2,314 in 2018. Now, up to this point, the curve was sweeping upwards at an exponential rate. But then the rate seemed to level off because in 2019, there was a break in the curve with only 2,890 cases. Then there were 3,503 in 2020. Now, if we continue this curve, well, now it's actually a straight line, out to 2021, we should hit 4,195 cases by the end of the year. And so far, the actual numbers the actual number of cases filed seems to track with that number. So let's dive into that estimate for this year and analyze it a bit more closely. That number, 4,195 cases, is a lot, especially because almost all those lawsuits are filed in only one of 3 district courts. So let's look at what happened over the first half of this year. During that half, almost 2/3 of the cases, or 1,178 for the first half of the year, were filed in the U.S. District Court for the Southern District of New York. There are about 40 judges appointed to the Southern District of New York. So assuming that there will be about 2,200 cases by the end of the year in New York, that means that there is going to be 55 cases for each judge just this year. So there's a very strong incentive for the courts to reduce the number of lawsuits filed each year. The second most popular state for lawsuits is California. And here the action is focused in the Central District of California with about 594 cases. And the least popular state is Florida, and specifically the Southern District of Florida, with only 163 cases. What's interesting about that number is that 123 of those 163 cases were filed before the 11th Circuit's decision in Winn-Dixie, and there have only been 40 cases filed since then. So the Winn-Dixie decision had a major effect in Florida, but Florida was already losing ground as a place for bringing these lawsuits. When we look at it, the month-by-month pattern in cases filed this year, we can see that Florida, which is just a tiny sliver in the total number of web accessibility cases for the year. It's interesting that all of the courts saw a downturn in April around the time of the Winn-Dixie decision, but California and New York seem to be picking back up since then, but while Florida continues to look like just a sliver of web accessibility cases. So seen in the context of this data, it's clear that Winn-Dixie won't have a great impact on web accessibility. Remember that Winn-Dixie is only the 11th Circuit, which really means only Florida in this case. People aren't filing in Georgia or Alabama, and specifically the Southern District of Florida. And the data clearly shows that that court is just not where the action is anymore for web accessibility cases. But actual data only goes so far. To give a fuller picture of how pervasive web accessibility litigation is, we should look more closely at that estimate of 4,195 federal lawsuits for this year, because the actual number of complaints is quite a bit larger. After all, that 4,195 are only the actual number of projected number of lawsuits filed in federal court in the United States. In addition to the federal courts, however, we also have the state court system. And there's a state court in each of the 50 states in this country. And state court systems like California are very popular for filing lawsuits. Also, most cases never even get filed as a lawsuit. Instead, most complaints get settled well before a lawsuit ever gets filed. Plus, there are hundreds of complaints filed each year with the federal agencies like the Department of Justice and the Department of Education's Office of Civil Rights. So that was the actual number, but I very conservatively estimated that the actual number was probably double that number. So that means that there would be about 8,390 complaints for the year. But other lawyers disagree with me and think that the number is 8 to 10 times larger. So looking at the lower end of that estimate gives a whopping high 33,560 complaints for just this year. Seen within this bigger context, uh, you can see that courts have really have a strong incentive to kick out as many of these cases as possible. Winn-Dixie represents an attempt to limit the avalanche of web accessibility lawsuits by limiting the protections of the ADA. Another way that the ADA can be limited is when bills are introduced in Congress to make it harder to bring web accessibility cases in the first instance. An example of this is the Online Accessibility Act, a bipartisan bill introduced by Republican Ted Budd of North Carolina and Democrat Lou Correa from California. This bill required plaintiffs to file their complaints first with the Department of Justice, but also provided for compensatory damages. And fortunately, that bill never became law. There are a bunch of problems with trying to curtail the ADA, and this gets back to the fact that the ADA is civil rights legislation designed to protect the rights of people with disabilities. There are always going to be people who will try to take advantage of laws like this and make lawsuits seemingly out of thin air. But when courts or the Congress try to cut back on the ADA, it has the unintended consequence of making life harder for people with disabilities. These problems only become magnified when it comes to the internet. On the one hand, the internet has the potential to break down so many barriers in our society. Shopping, for instance, can be a nightmare if you're blind or you use a wheelchair. And these barriers almost disappear when that experience is made available online and accessibly. Yet at the same time, a plaintiff's attorney can just as easily leverage that convenience and use automated scanning tools to identify dozens or even hundreds of potential lawsuits in an afternoon. So there's another way that courts have approached web accessibility cases to separate deserving plaintiffs from opportunistic lawyers. However, and that's to use traditional legal concepts to identify plaintiffs who suffer a genuine harm from those who don't. In general, I think that courts have done a fairly good job separating these categories of cases, but sometimes they fail to hit the mark. So in general, one of the most effective ways that courts have reduced their dockets in web accessibility cases is by applying the legal concept of standing to sue. In the United States, a plaintiff can't just bring a lawsuit anytime they feel like it. Instead, the Constitution requires that there actually be a case or controversy in order to be heard by the federal courts. In other words, the court won't hear a case that involves a purely hypothetical harm. So over the last 2 centuries, this has evolved into the concept of standing to sue. Plaintiff must have, one, suffered some actual or threatened injury. Two, that injury can be fairly traced to the challenged action of the defendant. And three, that the injury is likely to be redressed by a favorable decision. And it is the element of that alleged injury that courts have focused on in many of these web accessibility cases. And by separating out the worthy cases from the lousy cases in this way, the courts are using basic tools like standing to sue. And in most cases, this works great because it doesn't have any impact on the rights of people with disabilities under the ADA. So, for instance, one place where these limitations makes perfect sense is in the string of federally insured credit union cases involving web accessibility. I'm not exactly sure why, but credit unions were an early target for plaintiffs in web accessibility cases. So as you know, credit unions often have very specific geographic or membership requirements. For instance, you need to be a veteran living within 200 miles of Philadelphia in order to be a member. But this doesn't prevent a plaintiff from, say, Miami, suing that same credit union because their website was inaccessible. In these cases, the courts have had little trouble dismissing the cases because the plaintiff wasn't eligible to become a member of the credit union and thus suffered no injury from being unable to navigate their website. Another place where standing to sue has been successful, and more recently, is in a series of hotel accessibility cases in New York and California. These cases are quite different from traditional web accessibility cases because they don't allege that the website itself was inaccessible. Instead, they allege that the hotels failed to disclose information about the accessibility of its accessible hotel rooms. Now, that's a specific requirement under the new ADA Title III regulations that were issued by the Justice Department. But apart from that difference, the same legal principles apply. And in these cases, less than a half dozen plaintiffs have filed several hundred lawsuits around the country against smaller hotels and motels. And recently, almost all those cases have been dismissed because the plaintiffs has shown no genuine intention to stay at the hotel and could not have suffered an injury. In many of these cases, the plaintiff also alleged that they were just a tester, a concept that which was developed in housing cases alleging racial discrimination. But this idea has also been largely rejected by the court. Not entirely, just largely. This does not mean all is perfect, however, when courts apply standing requirements in web accessibility cases. And an example of this is how the US District Court for the Eastern District of New York required particularized injuries in order for Albert Rizzi to sue Hilton Hotels. To understand why this is a problem, I'd like to spend a few minutes talking about that case. So, Albert Rizzi is a blind advocate living in New York City. He's a founding member of IAAP, and he's actually a good friend of mine and a good friend of Thomas Logan as well. Several years ago, he tried to reserve a room at a Hilton hotel, but was unable to do so because the site was inaccessible. His mistake was that he didn't take excruciatingly detailed notes of what happened to him. Specifically, the court required him to identify the exact date and time that Albert visited the website, each feature on the website that constituted a barrier, an injury that resulted from said barriers, and a link tying each barrier to each injury. Now, while those requirements may superficially flow from the basic requirements for standing, it ignores the ever-changing nature of websites. But I'll have more to say about that when we get to Domino's Pizza in a few minutes. Applying these standing concepts too rigorously denies legitimate plaintiffs from upholding their rights under the ADA. I know Albert Rizzi, and I know he's not an abusive serial plaintiff, like many of the plaintiffs who bring these cases. And I really believe that he was trying to book a hotel room and was blocked because the site was inaccessible. But requiring plaintiffs to preserve the kind of detailed information that the court required Albert to present, however, is simply impractical and only serves to support professional plaintiffs, exactly the opposite of what the court should be trying to do. So after some thought, I've come to the conclusion that the only real solution to web accessibility is my original solution. Ultimately, it's the Department of Justice that needs to clarify its ADA Title III regulations for websites. Now, for those of you who've been working in this field for even a couple of years, you probably already know the sad story of the Justice Department's effort at creating its web accessibility rule. I'm glad to say that I was not at the DOJ when this happened because it's frankly an embarrassment. And I'm also certain in saying that I wouldn't have I would have gotten this done. In any event, the Department of Justice announced that it would develop new regulations for what private businesses and state and local governments had to do for web accessibility on June 26, 2010, the 20th anniversary of the ADA. Woohoo! This was done in the form of an advance notice of proposed rulemaking, or what we call an ANPRM, which really is the first step and asks a series of questions. Then we had to wait 6 years of silence. 6 whole years. Ultimately, on April 29th, 2016, they should have come out with a brand new draft regulation, or what we would have called an NPRM, or Notice of Proposed Rulemaking. Instead, they issued a supplemental advance notice of proposed rulemaking, which is kind of a rare event. It's called an SANPRM, which was just another set of questions. How embarrassing. So we all know what happened next. 2016 was, of course, an election year. And well, we all know what happened, how that turned out. 6 months after the Trump administration came in, they put the web regulation on the inactive list, even though both the business community and the disability community were clamoring for the regulation to be issued. But common sense was never a hallmark of that age, so the regulation was pulled entirely on June 26, 2017. Happy freaking Christmas, everyone. So I really think that the reason DOJ is the only solution to web accessibility is because the courts and Congress have already demonstrated that they're not equipped to deal with web accessibility. But an even stronger reason is that only by making WCAG into a legal requirement will it become an enforceable standard and create the incentive that businesses need in order to make their websites accessible in the first place. So when I started preparing this presentation, a certain someone at Equal Entry asked me if I was going to cover the Domino's pizza case. Good grief, I thought. After the Supreme Court denied hearing the case, what's to talk about? It's obvious which way the court is going to go, but I acceded to their request, as I frequently do to Thomas's wishes, and thought about how to incorporate talking about Domino's. Then it hit me. It makes a nice foil to cases like Winn-Dixie and raises some fun legal issues in its own right. So instead of ending on a note of doom and gloom, we can end on a cheerier note and talk about Domino's. So for anybody who's been working in web accessibility, you likely already know that the litigation in Domino's Pizza has been going on, well, since the Stone Age. Back in 2016, this case appeared on everyone's radar as a district court took a very narrow reading of the case and ordered that the case be stayed because DOJ was still working on its ADA Title III regulation. Then the Ninth Circuit reversed, and the Domino's appealed to the Supreme Court, only to get quietly dumped by the 9 justices. And then it ended up back in district court and went through discovery, and now it was time for motions for summary judgment, the last step before trial. And unless Domino's could find a Hail Mary pass, it was pretty certain to everyone that Domino's Pizza would eventually lose. And sure enough, they did lose on summary judgment. Now, when I blogged about this case last month, I compared it to Homer's Odyssey. So you could summarize that story as, well, they sailed from Troy and they made it home. But that doesn't quite do it justice. Sometimes the real story is about the journey and not the destination. And so too, the Domino's Pizza case had some interesting surprises beyond just the result of the decision. So we don't have time to dive too deeply into everything that the court covered, so we'll cover just the highlights. If you'd like to learn more about the case, I would direct you to our blog at Converge Accessibility. The first surprise was that Domino's Pizza could be liable as a franchisor for the franchisee's website. I had not even thought about that issue before. So as we know, in California, you need to show a connection or a nexus between what happens on a website and a bricks and mortar location. Fine. That's typical web accessibility. That's a typical web accessibility case in a nexus jurisdiction. But what if that website and the business are owned by 2 completely different companies? So in this case, you've got the franchisor, Domino's Pizza, which owns the website, but they don't own any stores. Instead, the stores, which are really the places of public accommodation, are all owned by the franchisees. That legal distinction can really throw a monkey wrench into the litigation, but the court didn't have any trouble saying that Domino's Pizza could be liable for it. Another pleasant surprise was that offering a telephone line alternative was deemed insufficient by the court. This defense to having an accessible website makes sense because the ADA only requires effective communication. But legal opinions are always based on specific facts, and the court held that waiting 45 minutes to order a pizza didn't constitute effective communication. But what's also interesting was what the court didn't say. Could a company, for instance, have an inaccessible website if the same products and services were available through a telephone number that had little or no wait time? Who knows? So the court also clarified that having multiple barriers on a site or revisiting the same site to conduct the same transaction or same type of transaction only gives rise to 1 violation under California's Unruh Act. This is important because Unruh provides liquidated damages of $4,000 per claim. But for our purposes today, the most important point of the Domino's Pizza case was how the court handled the standing to sue requirement. Specifically, the court noted that the Domino's site had changed over 7,600 times since the litigation started and was constantly in a state of flux. In that case, all that the plaintiff had to allege was that the defendant, quote, maintained a continually changing website that cannot be read by screen readers, end quote. This is obviously a totally different reading of the standing to sue requirement than the particularized injury requirement that was put on Albert Rizzi. So maybe Albert just needs to move to San Francisco. Well, that brings us to the end of our presentation today. I'd like to thank my friends at Equal Entry for inviting me to give my thoughts on the Winn-Dixie and other recent litigation. And I'd also like to thank all of you for your attention today. If you'd like to reach out to me, you can reach me at ken.nakata@convergeaccessibility.com anytime. Also, if you can't access any of these cases that I talked about today and you need a copy, please feel free to reach out to me. Thanks very much and have a great day.
Ken, we had a question in here. Can they receive a copy of the deck? And if so, would they just reach out to you at ken.nakata@convergeaccessibility.com?
Sure. It may take me a little bit of time because I was just working on it and I still have to make it accessible.
Okay. So that should answer the question. And as far as that case was concerned, the other presentation you had, you asked everyone to also reach out to you at your email there. I have another question. It says, I learned about the Inter-American Convention recently. What is the role and purpose when we have ADA?
I have no idea. Let's see. I wasn't prepared for that. If you're talking about the UNCRPD, that's different. That's and there's some movement with IAAP and with G3 ICT on incorporating web accessibility into that. But the Inter-America Convention, I don't know about.
Does anybody else have any other questions? No one has responded, so Ken.
We get you,
Oh,
everybody
wait a minute.
gets,
Hold on.
oh, okay.
When will we receive the recording? Tim, we'll have that out to you by next week. And it comes in by email. We had great presentation. Fantastic information. Thank you, Ken. Thank you, Ken and Elise. Yeah, Ken, thank you. Great working with you like this again. And it was really good information. I really appreciate it.
Yeah, thanks.
Okay, well, thank you, everyone, and we'll give you this time back. And if you have any questions, again, we'll leave Ken's email up here for another minute or so you guys can grab it. And we will be getting the presentation out to you next week. Okay, thank you, everyone. Have a great day.
Okay, thanks. Bye.
Thank you. Bye.